Right now, on Law&Crime Report, an NYPD officer has been arrested and stands accused of helping to run a cocaine trafficking ring in New York City. Plus, a 20-year-old Fort Hood soldier has been arrested in connection with the 2019 killing of 32-year-old Chelsea Cheatham. Cheatham was initially thought to have died due to natural causes, but an autopsy determined her death to be a homicide. And later, co-founder of the brand Salt Life has been arrested for the murder of an 18-year-old woman. Michael Houghton says the two were playing with a gun when it went off. This is the Law&Crime Report, diving into true crime and all legal stories making headlines. Good afternoon, I'm your host, Brian Buckmire, here at the Law&Crime Report. We begin with a story out of the NYPD, where an officer is being accused of being part of a cocaine drug trafficking ring that affected not only the New York City area, but also the Dominican Republic. Now, he's one of three who have recently been arrested, and what they're saying about this case is quite alarming and very bizarre. Now, not only did he participate in this drug ring, according to the NYPD, but he also is accused of using his knowledge of NYPD procedures and the database and giving that information to the other co-defendants so they can help evade the law and skirt the system. Let's start off by bringing in our guests here. We've got criminal defense attorneys Katherine Smith, as well as Dewitt Lacy, and of course we got Joseph Scott Morgan, our death investigator. Good afternoon to you all. Katie, this is right in our backyard. This is NYPD. This is cocaine drug trafficking. This is, I think, the beginning of a great movie, maybe 20, 30 years down the road. What did you think of when you first heard this story?
I think movie, and I also think, obviously, nightmare for this officer who is involved. You know, the first thing I thought of when I read this article was, how did they catch this guy? I think we're going to see a lot of information come forward because, as you know, if they're able to squeeze him, to have him to give information about this, we're going to learn a lot more. I'm assuming that, and I don't know, but I'm assuming that they may have gotten him on wiretaps. A lot of the details are yet unknown, and I'm looking forward to hearing more.
Yeah. Now, Dewitt, we have Amari Abreu, the defendant in this case, a 6-year NYPD vet. This just seems like the tip of the iceberg because, as Katie is describing, there could be some wiretapping, there could be some RICO charges. This isn't just a New York City issue. This might go well beyond that. What do you forecast for what this might face, or what this defendant, Abreu, might face?
Well, I would imagine that he might be facing some death threats. You know, you're dealing with a drug cartel. These folks are serious operators. And unfortunately for him, that means that those serious operators are going to be focused and pointed at him. As far as legally, I definitely think it means RICO charges. And you're probably seeing something that goes not only New York wide, but maybe even nationwide. New York could have been one of the main ports. And, you know, well, we'll have to see. You know, I think Katie is right. You know, if they're squeezing him for information, it just depends on how well he is connected with the criminal organization and enterprise in all.
Okay. Now, Joseph, there are no bodies yet, so we don't need your expertise just yet, but we're kind of touching on it. In this investigation, you hear a multinational drug trafficking ring, and I'm sure there's got to be fireworks off in your brains. What are you thinking we're going to see in terms of an investigation? Katie already told us about wiretapping. Is there anything else you can guess that we might see down the line here?
Yeah, and there is forensics to kind of dig into here, Brian, and this is why. You know, when you begin to think of the source of all of this, say the nefarious activity, but specifically the drugs themselves, particular cartels and organizations use particular chemical structures relative to the drugs they distribute. And I'm thinking specifically, and I know that you guys have been around courts long enough to know those items that the drugs are cut with. You know, whatever that might be, baby powder. Baby powder, can be baby formula, quinine, all these kinds of things. And it goes to a distinctive fingerprint, if you will, and a chemical fingerprint, something that you can actually tie back to. And boy, let me tell you, that's powerful information when you begin to kind of tie this thread back. And the first thing I heard of, I was kind of going back in my mind. I remember when I was a kid and I read Serpico, and I began to think about all the stuff that I've heard over the years relative to like the Knapp Commission, going way, way back with all of the corruption that haunted NYPD for years and years. This is not just bad for this officer, it is bad for the department.
Yeah, and they're saying that the real crux of this as well is not only did on one occasion he actually participated in selling these drugs, but also that he had 4 other co-conspirators, and he used his knowledge of the NYPD, their database, and also how they arrest people to help protect that organization. If anyone's going to get the book thrown at him, I think it's going to be a brew in this case. Let's switch gears to another case where we talk about Fort Hood. Now, Fort Hood has been in the news for quite some time, talking about missing peoples, suicides, and death. But hopefully this is a new chapter walking towards justice, as the police are saying they arrested an individual in connection with the death of Chelsea Cheatham. I'm talking, of course, about Specialist Corey Grafton, who was arrested recently for the death of Chelsea Cheatham. Now, if you remember, she was a young woman who was from Fort Hood that was found in a room where they at first had believed that this was natural causes. This person had just died of natural causes, but upon investigation, they determined this to be a homicide. Joseph Scott Morgan, we're in your wheelhouse here. Talk to us about that transference of, okay, we came across a young woman's body. Of course, there's this background of it's Fort Hood, and we have homicides and suicides, and we've got to look at this. Talk to us about how an autopsy can go from this is natural causes to homicide.
Well, if there is specific trauma that would not have originated from, say, for instance, a fall or something like this, you have to begin to look at other issues regarding the specific trauma. Let's say, for instance, if this was a choking, or if this was some kind of sexual assault that led to homicide. Now, my understanding, Brian, is the fact that there is actually a DNA that has been recovered from this case, just like we were talking about previously with connectivity. DNA is the ultimate connector. It is that thread, that biological thread that connects everybody. And they will already have the accused sample. If he is a United States troop, they will have his sample in the bank. Okay, so it would be very easy to tie him back to his physical presence with the body. And this is just a horror show, particularly as a veteran, as I am, an Army veteran. It breaks my heart what has been happening at Fort Hood these past few months in particular, but I think this has gone on longer than we can imagine.
Yeah. Now, Dewitt, we so far what we've got is that the defendant has some DNA on the body of the victim, being Chelsea Cheatham, and that there's at least one witness that puts Corey Grafton in the area around the time of the death or the discovery of the body, saying that he was leaving the area. When you hear the words discovered DNA on the body, that's pretty vague. Where can we be going with that? Are we talking, Dewitt, are we talking DNA under the fingertips, DNA on the clothing? And even then, you can go into, is it blood, semen, saliva? Dewitt, is this just a number of doors that we've got to explore before we really get to the heart of this case?
Well, look, DNA could come from a lot of different sources. Yeah, it could come from skin underneath someone's fingernails if there's been some type of struggle or violent fight. Of course, if there is any indication of rape, there could be, semen or other body secretions that could appear in a vaginal swab. But DNA evidence is a lot different than it was, decades ago. Decades ago, DNA evidence wasn't as sophisticated. Now it is extremely sophisticated and almost guarantees that you're looking at the individual defendant that the DNA is related to. So I don't know that there has to be a specific test for each type of DNA sample. DNA is DNA from what I understand. Maybe Joseph might be better at answering that question.
Yeah. Now, Katie, the Killen PD utilized what was called the Sexual Assault Kit Initiative, or SAKI program, to match Grafton's DNA with DNA found at the crime scene. And so it appears that this is another case where DNA is pointing us to one person. What do you think we can expect in this case where it was cold for not too long? This is a 2019 murder, and now we're getting DNA as well as other testimony pointing us in the direction of this defendant.
Well, even with something as damning in many ways as DNA, there's so many other ways around it because, ironically, it's become more sophisticated. So now we have, and Joseph Scott Morgan would be the guy to really go into this. But now we have touch DNA. So there's lots of different ways that DNA can be transferred by, if I rub my hands over somebody and then it gets onto them, that can be a transfer of DNA where it doesn't mean that you did anything nefarious. In addition to that, if there's DNA from sexual act, it can be consensual. So DNA isn't always the magic bullet to guilt, but it certainly is hard to get around that there was physical contact, and that's going to need to be explained.
All right, we're going to continue with more of these stories as we cover here on the Law and Crime Trial Network right after this break.
My life changed forever because somebody did a stupid thing for nothing and took his life.
But also, being the kind of people that we are, we can forgive this guy. But I think that he needs to do his time for the rest of his life. He took my son.
Not just from us, but from the world.
Yeah.
For no reason.
Those two were David and Sandy Hassell, the parents of the kids. The kids are all right actor Eddie Hassell. You may have seen him in that and other movies. He was a victim in a robbery, a random robbery from what we're understanding, gone wrong, that turned into murder. And the quick clip that you saw there of the 18-year-old gentleman, Dijon Antone, he is the accused defendant in this case, where we're finding out that a robbery went wrong and it ended up with Mr. Hassell having a bullet to his stomach and later being found dead at the scene. Let's bring our guests back in and discuss more. Dewitt, this is just a random tragedy. I mean, there's no other way, I think, of putting this. There was no rhyme or reason other than someone attempting to rob another person. And again, we have a senseless death. We may often see this case far too often. The charges are capital murder. What would you project is going to happen in this case as we follow it along?
Well, I think the prosecution is going to be pretty fervent here in the prosecution of Mr. Antone. Not only is it a random act of violence, but, you killed a young guy who has some popularity as an actor. And that means something in the prosecution's eyes, because once they go before a jury, you get to tell, the prosecution will have the ability to tell the story of the life that could have been and even the life that was of Mr. Hassell and cut short by, the random and violent acts of Mr. Antone. So I would expect the prosecution to really go after Mr. Antone pretty aggressively. I think you're seeing some first-degree murder charges, definitely felony murder, but I don't think anybody's going to be letting up easy on Mr. Antone.
Yeah. Now, Joseph, kind of walk us through this, because we can all say, all right, shot in the abdomen and died, but you've got the credibility and the credentials behind it to really be able to analyze what that is. What we're finding out is this is happening at 1 o'clock in the morning after Mr. Hassell is walking out of his girlfriend's home in Grand Prairie, Texas, and there's, as you said, a robbery gone wrong, and he takes a single bullet to the abdomen and is later pronounced dead at the scene. Talk to us about what that damage would have been to his abdomen and how his last moments would have been after that robbery.
Well, most of the time, Brian, a gunshot wound to the abdomen is not a sudden death. This is something that if it passes through the anterior or front of the stomach or front of the abdominal area, if it clips a couple of vital organs like the bowel, they all have blood supply, or if it hits a vessel specifically, then there will be a slow bleed out. I've worked a number of these cases over my career. It's an agonizing way to die. It's not like taking a shot to the brain. He would have lingered for some time. It would not surprise me to hear the forensic pathologist on the stand to go into great detail about this. He'll also talk about on the stand how much blood was contained in his abdomen, the volume of blood that his organs were left floating in. And there'll be a time component tied to that, Brian, and that's what makes this all the more agonizing and painful.
And let me correct myself there, because the incident is reported to happen at 1 a.m. in the morning. Police officers arrived at 1:50 a.m. and Mr. Hassell didn't die at the scene, but instead died at the hospital. So Joseph Scott Morgan, as usual, absolutely right. This would have been a situation where he would not have died immediately, but instead at the hospital. Unfortunately, those life-saving precautions were not able to save his life. Katie, let's bring you in on this one as well. I don't see a defense here. I know oftentimes we can look at a case and say, all right, maybe the defense has this, maybe we didn't get the right guy. But this seems like an ID case through and through. And if there's any amount of surveillance or maybe a witness, that seems to be it for the defendant here. What are your thoughts?
I agree. There's a couple ways to attack these things, right? There's always the wrong guy. You completely have the wrong guy. Then there's always those mitigating defenses, such as, well, it was self-defense or there's some insanity issue going on. I don't see any of that apparent from what we've been told. And so with that, and due to the high-profile nature of this, I'm sure the defendant who's been arrested did not know that he was attacking someone who was famous. This high-profile nature might shed more light on this, such that it will put the defendant in a little bit more pressure to possibly plead out. So I imagine, depending upon what there is there in terms of evidence, that he might cut his losses, not go to trial, and take a plea.
Yeah. Now let's switch gears to another story, another tragic death out of what seems to be just, unfortunately, a lot of foolishness. Now, we have Salt Life brand co-founder Michael Hudo, who's 54 years old, ended up killing his 18-year-old girlfriend, Laura Duncan. Now, the story that we're hearing so far is that the two were inside of their Florida hotel room, and while they were playing with finger guns, actual pointing at each other with their fingers, mimicking guns, Michael decides to pull out a real gun and, still in joke and jest, shoots Grace in the stomach. Now, the response seems kind of peculiar here, because he wasn't arrested at the scene. He's arrested miles away at a gas station in somewhat of a delirium, saying, did I hurt Gracie? I think I hurt Gracie. The parents end up calling for a wellness check and say, hey, we haven't seen our 18-year-old daughter for 48 hours. We know she has this 54-year-old boyfriend. There may be some suspicions of drug use to kind of keep her in that relationship. That's for another segment. But again, this is just a tragic death all around. Katie, let's start with you. I don't see a defense here. I'm not sure if there's going to be one, but when you first heard the story, what kind of came to your mind as a defense attorney?
Let me tell you, as a person, what first came to my mind was accident. A lot of times people use that as an excuse. How many times do we hear these types of excuse that there wasn't an intent to shoot the person? I imagine we're going to hear a lot of evidence about drugs, about people not having the requisite state of mind to commit this type of crime. But immediately I got that funny feeling that, was this really an accident, or was this something that was done on purpose and he's trying to cover it up? Again, more to be seen on this.
Yeah. Right now, bond was set at $255,000. The charges were manslaughter as well as possession of a weapon. It appears that at the very least, Dewitt, that we have manslaughter charges and not murder one, murder two. So maybe no intent is what the prosecutor is saying thus far. Do you think there's a possibility that murder one or other murder charges could be on the table as we dig deeper into this?
Sure. I think there's got to be the likelihood that some other type of murder charges will arise, given further examination of the facts surrounding this circumstance and incident. Look, playing with guns while you're high, I think Katie is absolutely right. You're going to hear a lot of talk about drugs, a lot of talk about not having the requisite intent for murder, but there's depraved heart murder, there's felony murder. So I think there's a lot of things that could elevate this from a manslaughter charge to a greater and more serious murder charge, given whatever evidence is found. It's very early in the investigation right now, but I would imagine they're going to find some evidence of some felony wrongdoing, which I think increases the likelihood of a more serious murder charge. And I don't believe that many folks are going to have a lot of sympathy for the fellow.
Now, the detective actually found the defendant, Hutto, in the hospital at Jacksonville, because again, he drove away from the scene. He was brought back to the hospital because as the officers who at least detained him, he was speaking gibberish, some sort of delirium, so they thought there was a medical issue there. And so perhaps the prosecution will get some sort of information about what was in his blood system, if he went to the hospital and got checked up. And whether or not there were drugs in his system is definitely going to be a huge part of that upcoming potential trial if it does go that far. We're going to take a quick break and come back with more here at the Law and Crime Report as we dive into true crimes and major headlines across the country. Welcome back. So as you know, we've been covering this case out of California. Brandon Willie Martin was found guilty of all charges. Now that stems from the triple homicide of his father, his uncle, and the ADT technician who was there installing the security system from what the prosecutor was saying was meant to protect the family from the defendant. But that didn't happen because the defendant was released after being 5150. That's the technical term in California for when an individual is mandated to stay in the hospital or a mental facility for 72 hours. But for Brandon Willie Martin, he was released after only 48. Now, he was found guilty of all the charges, and the defense is really trying to drive home the theory that there's a mental disease or defect and that the death penalty, although it's just a kind of academic conversation right now because California has put a moratorium on the death penalty, but still they're arguing whether or not it should apply here, that the death penalty should not apply to Brandon Willie Martin because he has some mental health issue that we are going to hopefully find out later on this trial. Let's first begin with opening statements in the penalty phase. Remember, it's different than the guilt phase. This is the penalty phase by the prosecution.
Mitigating circumstance, as you heard, is any evidence that's presented that somehow lessens the blameworthiness or the culpability, moral culpability, or the wrongdoing that the defendant has done. The aggravating evidence that people will rely upon will be the circumstances of the crime, which, as the judge has read to you, is also known as Factor A, and any other violent criminal activity committed by the defendant that involved the use or attempted use of force. The Factor A circumstance of the crime, that word circumstance does not merely mean a temporal and spatial relationship to the crime. In terms of the crime itself, you have the facts and the elements. What were the facts and what were the elements? Did facts show that the defendant did an act that caused the death of another human being? When we talk about the circumstances of the crime, it extends to those circumstances which surround the crime in a material, moral, or logical way. What flows from the elements and the facts of this crime? It extends also to the specific harm caused by the defendant, including the psychological and emotional impact on the families of the victims. You can consider Michael Martin sitting there watching this horror unfold in front of him, knowing that he will be next. Consider this was a brutal attack against his own family, dad, his uncle. Consider Harry Swanson, there, that the family dies because of his death. You can also consider, as a circumstance of this crime, the lack of remorse at the time of the killing and the callousness with which this killings was done after he had murdered these three individuals. When in fact, we know that Ricky Anderson was still alive when he went through Rick's pockets. As he lay there dying, and rummaged through his pockets, rummaged through Michael Martin's pockets and Barry Swanson, stealing their personal belongings. That's a circumstance of the crime that shows a callousness on the part of the defendant. And then, to add insult to injury, he drags his own dad's body into the garage so he can get himself up to heaven.
All right, so he's guilty. Push that idea aside. Now the question becomes, how long, if any, time should he spend in jail? Now, obviously, there's mandatory minimums for the homicide charges, but with this mental health issue, that's going to play a huge part in this case. Dewitt, I want to jump in on this one with you first. So this is kind of my issue with this. California is asking for the death penalty. The governor has already come out and said he's putting a moratorium on it. That's his first term in office. He's got another 2 years before re-election, possibly gets elected again to another 4 years. So potentially, if he stays on, that's 6 years at least that California will not have the death penalty unless someone gets elected and decides to change course. So is this all just an academic conversation at this point? Because he's not going to be put to death. California has already said they're not going to do it. What are your thoughts?
I think you got a point there. You know, in some regards, it's very academic. You know, Governor Newsom has already said that, as you said, he's not going to allow death penalties to be executed on his watch. I don't see him not being reelected. He will be reelected if he doesn't run for some greater office. Hint, hint, wink, wink. You heard it here first. But also, I think there's really something to be said about, you know, the state of mind that this young man had. You know, he obviously had some very serious mental health issues going on. And I think that would be another a wall, if you will, that may prevent the death penalty from being attributed to him in this penalty phase.
All right, Joseph, let's look at it from the other side, because, of course, I'm a defense attorney. I can speak out of both sides of my mouth. If you get the death penalty here, then hypothetically you can say, well, we're going to leave this for the voters to decide. Because if you get death penalty after death penalty after death penalty, and the state of California says, hey, we might want to elect someone who's going to end up going through on some of these cases, because this guy, and again, not the biggest fan of the death penalty myself, but he murdered 3 people with a bat. So could the prosecutor be saying, hey, I'm putting this forward because I want voters to decide down the road? And what are your thoughts on that one?
Yeah, I guess you might think that the prosecutor might be using this as political leverage on some level, but I just, you know, along with Dewitt, I don't see this happening. I don't see this guy being put on death row. I have my own objections to the death row for death penalty for a variety of different reasons. However, you know, at some point in time, you know, I just kind of feel like that it's a lost cause most of the time. I prefer the idea of, you know, just sticking these people away and be done. You know, be done at that point, and quit rehashing this thing relative to the death penalty, because it wears thin. Now, I have to say very briefly, these are brutal crimes, and what's really interesting, Brian, about this case is that these people were brutally bludgeoned to death with a baseball bat, which in his hands, because he is a former professional baseball player, the fact that he utilized this tool shows the level of lethality. It goes to a more planned kind of event. You know, this isn't just necessarily a weapon of opportunity, or it could be painted that way. This is something he chose to use. So it is a horrible level of brutality that we're seeing here.
Let's listen to a little bit more of the prosecution's opening statement in the penalty phase, to decide whether or not the death penalty will remain on the table.
You're asked as jurors to do certain things in this case. You're asked to weigh the heartache, the pain, and suffering of the families in this case. Consider that suffering, the loss of their loved ones, as aggravating circumstances in making your decision. Consider all the evidence, just as you did before you make your decision. Dedicate yourselves to the truth and come into the right verdict. And come into that right verdict, you will make a decision. You will make a choice in the same way that the defendant made a choice when he chose to kill 3 men in the most brutal and callous way. But the defendant chose his own path. He chose his own path, and he chose to kill. Ricky Anderson, Michael Martin, and Barry Swanson had no choice. They had no choice. The defendant, an evil man, killed 3 good men. And after hearing all the evidence, we will ask you to render a certain type of verdict. A verdict that the brutality and callousness of this horrible and evil act demands.
Now, Katie, I'm assuming, and I think most of us would, that the prosecution discuss the fact that they're pursuing the death penalty to the family, because the family plays an interesting role in these cases where they're both the victims, but also the family of the defendant. And the prosecutor said something very powerful there. Think of the heartache of the family. How do you walk that tightrope as either defense attorney or prosecutor when the family is so ingrained in the case on both sides? Because if Brandon Willie Martin does get the death penalty, this family lost a father, an uncle, and a son/nephew. You're adding to that list, even though one of them caused the death of the other two. How do you think the criminal justice system really kind of squares that peg?
What a good question, Brian, because it's so tough, right? There's really no justice to be had in this situation for those exact reasons and those conflicts that you stated. You have to wonder, because of the academic nature of seeking the death penalty here, if that's something that the family really wanted. It seems as though it is, because there doesn't seem to be any real bite behind seeking the death penalty other than trying to achieve what the family or the prosecutor might deem justice in this case. Because realistically, we all know what's likely going to happen is he's going to be in jail for the rest of his life, and throughout that, probably getting some serious mental health treatment, because as we know, he was sick, but he also was extremely violent. And it's very hard to thread that tightrope, especially with those conflicts that you said.
Yeah. Now, Joseph, as the resident expert of the four of us, when you hear this young man's story, Brandon Willie Martin, do you have any question in your mind, not the legal insanity or the standards of, like, can he appreciate the level of crime? Does he know right from wrong? Is there any question in your mind that there is something mentally, chemically, physically wrong with his ability to process information based on what you've heard in this case?
No, I think that there is pathology here. Obviously, there is. I think that, was that question, this whole idea of menace rea and actus reus, do you have convergence here? And for me, it would seem that there was some planning that went into this. I think the most striking thing for me, the rifling of the pockets to take away cell phones and that sort of thing. It's not, and this is a very thin line to walk, Brian. I don't know if this guy is walking around seeing pink elephants and he's having hallucinations or anything like this. I don't know if it's that severe, but there was a lot of rage. There is pathology, but I don't know that it was completely debilitating to that point. So, I think the bigger question, like in all of these cases, is that there was an awareness of mental problems here. We go back to his mom, where, if you can imagine this, putting scissors to your own mother's neck. Uh, there is a failure here in the mental health system. Let's just be completely honest about that. Just like when we talk about defects cases with protection of children, and the government has failed in this area, and we're seeing this day after day after day. So, yeah, there is mental pathology, but there's also a combination of personal responsibility too.
Exactly. Let's take a quick break, and when we return, we'll look at the defense's opening statements in the penalty phase, because this is really where they're going to be pushing, maybe even more so than the guilt phase, that Brandon Willie Martin was not of his right mind at the time of the crime, and they're trying to win that insanity defense. But more when we come back. All right, so as we continue with the Brandon Willie Martin case, let's look now to the defense's opening statements, and this the penalty phase, where the defense at the get-go has been saying there is a mental disease or defect here, and they're attempting to make this argument to save Brandon Willie Martin from the death penalty. Let's take a listen.
This is going to be a difficult process for you. I told you that at the beginning. Here we are. Each of you will have to make your own moral judgment about this. Mr. Kurtz told you last week you collectively made a very important decision in this case. That guilt verdict guarantees Brandon will never, ever walk the streets again. We respect that decision. He's going to die in prison. talk about that. The only question really, is he going to die God's time or because of this case?
All right, so we're kind of alluding to it here. I think the defense has all the facts before it that can make for a strong argument. But Joseph, you narrowed in on, I think, what would be the defense attorney's fear in this case as to whether or not there's a mental health disease or defect argument. I'm going to throw it to Katie. Getting out a day early after being 5150'd, the decline of his mental and physical abilities from the time he was in the MLB till today would all suggest that this case is ripe for a mental health defense. But you get these little things like rummaging through the victim's pockets to get the keys and driving away. How do you think, I mean, that's the elephant in the room for the defense. How do you address that in a way that says, yes, my client has these issues, but he's also capable of stealing someone's keys and driving away?
Right, Brian, and there also is more of the details about how he acted even when he was actually confronted with how he interacted with the canine dog. And there's a lot of fodder there for the prosecution to say, sure, this guy might be troubled, but he absolutely knew what he was doing. And this evinced consciousness of guilt, right? But on the other side with the defense, you can say, sure, he knew to some extent what he was doing, but he didn't really appreciate the severity of what he was doing. He was suffering from delusions. All of that, of course, has to be hinged on the expert testimony that will shed light specifically on the type of mental health issues he had here. So like with every one of these cases, it's really, really a battle of the experts and very, very fact specific.
Yeah. And Dewitt, Aaron Keller and I were having this conversation. We were focusing on the dog aspect of being chased by the dog and fighting off the dog. And he was trying to make the argument that that would show an appreciation of right from wrong. But for me, a dog owner, especially a large dog owner, I said, Aaron, let me sick my 70-pound Doberman after you and see what you're appreciating, if you're thinking through things or if it's just straight fight or flight. So how do you see that whole running from the dog, reaction to the dog, because that is one of the charges here. How do you see that playing out in this whole storyline for the defense?
I don't know that that is going to be determinative of whether or not there is a finding of some type of mental defect or a mental issue with Mr. Martin here. As well, I'm not sure that rummaging through the pockets, as damning as a piece of evidence as it may be, to demonstrate that he at least had the ability to think, I don't know that that necessarily severely impacts somebody's determination of whether or not there's some type of mental defect. All of this is because, look, mental defects don't necessarily mean that you don't have the ability to think or form rational thoughts. However, it could be a mental defect where you couldn't control emotions and a rage, such as some type of schizophrenia or some type of bipolar disorder, where there is a chemical imbalance and they just lack the ability to control the rage. And so they have to be, sedated in some way. Maybe that's a defense that could be given that shows that it wasn't necessarily that, he wanted to do this, but he couldn't control the impulses. Who knows? That, like Katie said, will be up to the experts to determine what facts and what information is going to be given to the jury. However, it's not a good place for the defense to be in, although I don't think it's going to be outcome determinative about what necessarily he did after the fact.
All right, let's take another look at the defense's opening statements in the penalty phase and see where we can glean where this case is going.
To look at the photos, you're going to see a difference. I want you to pay attention, guys, about what Michael Anderson testimony about that. Talk about it. I mean, just look at it. He even used it from Sean as well. He's going to talk about the change. We look at this picture. We're going to hear from Emily Duran. She and Brandon were love at first sight in elementary school. They were boyfriend and girlfriend all the way through the senior year of high school. He's going to talk to you about Brandon, how he was. All these years being together. Bottom right, there they are in elementary school. Taller and has bigger. Get Brandon's face in these pictures. Tomorrow you're going to see the glow in his eye. What he has ahead of him. Great opportunities. Again, Emily's going to talk to you about that. She's very close to them, obviously, and his family. They break up the senior year because they're all going in their own directions. But Emily will tell you that she maintained contact with him. And all of a sudden, he changes. Same time frame. He becomes paranoid. He's sending her these text messages that don't really make sense. She doesn't understand what's going on. She notices, this is what I need to. You're going to hear from Jamal. This is a cousin tomorrow as well.
Now, Joseph, the defense is talking about how in his late teens and almost into 20, because Brandon Willie Martin committed this crime when he was 22, but at 19 and 20, there was this light in his eyes. He was a completely different person. And then over the last 2 years, something changed and kind of flicked into him, where he had these rage episodes and all these things changed. And I think that's what the defense is really honing in. Now, I'm sure you get this at the coffee shops, on social media. You have people be like, I know what it looks like when crazy hits someone. I know what it looks like when you hit someone in the head with a bat. I've seen TV, I've seen movies, I've seen this. And part of your job, I would assume, is kind of demystifying people from what they believe is true and educating them on the facts. Do you see a bit of an uphill battle for the defense and maybe pulling back what the average Joe or Jane would think mental health looks like, assault looks like, degeneration of the mental stabilities looks like, and having to re-educate them? Or do you think the facts are there to kind of walk that easy path?
Well, it's really hard to get past, the crime scene images that these people would be subjected to relative to the gore that's there and the injuries that all three of these poor victims sustained. However, I will say this. If the defense can secure a really top-notch forensic psychologist that can go back, and we refer to these as retroactive record reviews and examinations, and sometimes this involves any kind of medical record or mental health record that the individual has, and also interviews with people from his past, and they can create a definitive timeline moving forward, and they can kind of show this progression or decline, if you will, in the mental status. That can be equally as powerful as well. However, that's the caveat to this is, do you have an expert that is capable of explaining this to the decision makers at the end of the day? And it's like any of us that work in forensics. We can have all the degrees that you want, but if we're not capable of actually communicating with the decision makers, whether it be a judge or a jury, that's the problem.
Yeah. Now, Katie, we've seen this. I think Joseph is somewhat alluding to a battle of the experts, and we're probably going to get one from the defense and one from the prosecution. We've seen them go both ways, and sometimes their credibility or their resume or what they did and didn't review, it really gets held against them or for them. How would you predict this battle of experts in this case with the facts you know so far?
Well, the battle of the experts is always interesting because, if you get as far as trial and you're actually putting on a defense or a prosecution, you've got experts, because you wouldn't go that far if you didn't, right? And so we're definitely going to see experts that advocate one side or the other. And to me, a lot of it isn't bearing down to the science necessarily, or even the qualification of the expert. It's really that smell test, because at a certain point, the jury's going to go back there and they're going to say, we have two doctors saying that there are two reasonable explanations for this. What makes sense to us applying the factual reasoning that's presented? And so I think that a lot of times reasonableness prevails, for lack of a better word. And I would be surprised if they didn't find that he had some mental health problem. The question is whether or not it was sufficient to take down his mental reasoning to the point where he wasn't liable for his acts.
Which leads me, Dewitt, to my final question, because we got to head out soon. Is it ethical for the prosecutor to be seeking the death penalty when there are so many valid concerns as to the mental health of this defendant?
I think so. I think the prosecutor has to do their job because it is not, look, the jury is the decider of fact, and they decide whether or not there is a valid mental health issue that would prevent Mr. Martin from being able to understand and or appreciate or form, I guess, the requisite mens rea that would allow the death penalty to be applied in this case.
Absolutely.
Their job is to prosecute. So I think it is ethical, albeit if I ever held knives to my mother's neck, it would be a problem.
Gotcha.
And I think anybody who hears that is going to agree.
Joseph Scott Morgan, Katie Smith, thank you for joining us. We'll be back on a regular scheduled program after this. Have a nice night, everyone.